monetary fund to support Barbados' economic recovery and transformation plan.
Seconded.
Government business resumed.
Government business, no order be there. Member for Christchurch South.
I'm obliged to you, Mr. Deputy Speaker. Your Honor, there are not many issues that touch public sensibility as viscerally as the death penalty. There are several issues that pass through the public domain for discourse among people. But when one comes to the issue of the death penalty, it is normally an area in which one abandons political affiliation, one abandons narrow political interests, and personal and individual conviction comes to the fore. It was almost fascinating, as an example of that, to observe the exchange between the Honourable Leader of the Opposition and the Honourable Member for St. Thomas this morning, to whose contribution I eagerly look forward. But even at that level of exchange, there appeared between those two to be some commonality of thought and conviction on the issue of the death penalty. It may be that they belong to the same generation, and I'm not far behind. And I know that definitely they come to life and they come to this chamber with that sense of values that date back to a childhood which was stable, in which they were taught that law and order was to be respected. It clearly dates back to a time when authority was respected, and that was a time in Barbados in which the death penalty was taken as being the right thing to do in the event where a person was found guilty of murder, or indeed where a person was, in some cases, found guilty of manslaughter. There were people who still felt that a life was taken and that the only recourse was to take that person's life. That is not within my immediate contemplation this afternoon, Your Honor. I want to explore the legal and constitutional matters which spring from this amendment that is brought before the House. It is a matter of some regret that this amendment comes only because the Caribbean Court of Justice has given a ruling in a case called Nervais. I think that's it, that is the name. It is ironic that men who commit these very heinous offenses normally have their names celebrated in parliaments and in legal discussions, in law reports. They become celebrated figures, although what they have done is not worthy of any celebration. So I won't call the name again. But it is that case that has caused this Parliament to reach this point today. And I did say it is a matter of some personal and professional regret, because we ought to have been at this stage a long time ago. we ought to have been amending the law that mandated a judge to sentence a person to death when a jury said that that person had been guilty of the offense of murder. It has taken, now this is a new parliament, so it is not to reflect on this new parliament. But I cannot pass unless I criticize an earlier parliament for its delinquency. As I said, we should have been here a long time ago. When we were celebrating 50 years of independence, we were still without all aspects of our sovereignty. And I will say what I mean by that. There's a section in the Constitution, section 26, and it is called ordinarily the Savings Law Clause. And I am addressing you, Your Honor, as much as I am addressing the public, and to give explanation to this so-called Savings Law Clause. When we received the Constitution in November 1966, that Constitution contained a section 26. That Constitution also contained a fundamental rights provision. In other words, that Constitution gave to the citizen the right to life, the right to freedom of association, the right to freedom of speech. It gave several rights and freedoms that we call fundamental rights. So that here was the Constitution in November 1966, given to every Barbadian citizen his fundamental rights, and that the state could not abridge those rights. They were fundamental. Every citizen had the right to the exercise of those rights, even against the powerful state. But here was the same Constitution at section 26, saying to the citizen that any law that was passed prior to 1966, any law that existed prior to 1966, which he felt, or which objectively it was felt, collided with or infringed any of his fundamental rights, that any law prior to 1966 remained good law. In other words, he could not challenge that law that existed prior to 1966, even if he felt, and even if the courts felt, that that law abridged any of his fundamental rights. And that is why we refer to it as the Savings Law Clause. It saved laws prior to 1966, even if those laws were in conflict with your fundamental rights derived under the Constitution. So here was a Constitution giving rights, and here was the same Constitution asserting to the citizen that any law prior to 1966 that collided with those rights remained good law. And the law that we've come to amend today had been one such law. That law was contained in the Offences Against the Person Act. Now, I said earlier that it really touches questions of sovereignty. Sovereignty being that right and capacity to govern the entire geographical area that is called Barbados. But I press on from that. And to indicate to you, sir, that looking at the offenses against the person act more particularly. That act said what we all know it said, but let us say it again. That when a jury found a man guilty of murder, the judge had to. There was no choice. And I think the Honourable Member for Christchurch East explained it this morning. It was automatic. It was almost ritualistic. The jury finds the man guilty of murder, and the judge literally read the sentence. He had no choice in the matter. Is there not, or was there not then a sense in which the jury, those 12 men and women, were determining what was to be the sentence? Because a jury went into that case, a jury went into that jury box, knowing, having been told by the prosecutor, and they went into that deliberation as to a verdict, knowing that a verdict of murder would result in the man's possible death. I submit to you, Your Honor, that there's a sense in which the jury was passing the penalty of death, was issuing the penalty of death, not the judge. The judge's role, in my view, in a very real sense, was ritualistic. He was reading what the law mandated him to read. And I submit that for this other reason. And to ask the question, when we come to amend the law, in the words of the Honourable Member for Christchurch East, when we come to amend the law, is there not a case for a further discussion as to whether the discretion to execute or not to execute, whether that discretion should reside with the judge alone or whether it should reside with the jury? I submit to you, Your Honor, and I say to the citizens of this country, that there are certain parts of the United States in which the system says that after a man is convicted of the offense of murder, in their jurisdiction it would be a first-degree murder. The jury, and this is only in some states, the jury then holds a separate deliberation. It becomes almost a separate trial. And it is the jury that has heard the case that then tries to decide whether the person convicted, whether the person that they convicted is due the penalty of death. I want to submit to you, Your Honor, and I want the public that feels very, very strongly on the issue of the death penalty to consider whether the responsibility, the heavy and final responsibility of passing a sentence of death should fall on one person, whether it should fall alone on the shoulders of a judge, or whether, as in some jurisdictions in the United States, that grave and weighty decision should be made by a panel of 12 persons, and whether that panel of 12 persons will be allowed only to pass that sentence of death if they are unanimous. As I've said before, Mr. Deputy Speaker, under the system that we are changing today at the urging of the Caribbean Court of Justice, in a very real sense, it was the jury that was not only convicting, but condemning that man to death. As I said, the judge's role was ritualistic. This amendment today places that entire responsibility on the judge himself. And I think we as legislators, we as parliamentarians, need to invite the public into this discussion. Because this is a discussion that has no political borders. This is a matter of individual conscience. an individual conviction deriving from the state of one's value system. And therefore, the public must be and might be asked to consider whether, if in the event that they wish to preserve the death penalty, do they also wish to preserve that discretion in the hands of a single person who happened to have conducted the trial as a judge? Or whether that heavy responsibility should find itself distributed among 12 persons acting as a composite whole, a jury, and that it would only after they have found that the person ought to be condemned to death, that they must do it unanimously. That's a heavy responsibility. And the public that invests so much emotional energy, that the public ought to be engaged as to what is their position on it. Is it one man, or should it be a jury of 12 persons? As I said, Your Honor, this Section 26, this savings law clause, I come back to it. The CCJ sitting a few weeks ago reminded this country, and in particular, reminded this Parliament, that savings law, that Section 26 of the Constitution, should not hold a country hostage, or should not hold a country's legal system hostage indefinitely. Indeed, that court remarked that in Belize, when they introduced their independence constitution, their savings law clause was expressed to be for a period of 5 years. In other words, it was transitional. What the savings law clause does in Belize, and what it ought to have done in Barbados 50 years ago, was to have urged the Parliament to get busy. That any law prior to independence, which was unjust, any law that was ripe for amendment, the Parliament of the country was urged to amend that law, to change that law, to update that law, to modernize that law. And so, that Belize should not have found itself in Barbados' position 50 years after independence. The Belizeans say that that savings law clause will only exist for a period of 5 years. In other words, it was given the Parliament of Belize 5 years to put bad law right, to correct injustice within the legal system. We were around here, was it 2016? Making a song and dance about 50 years. When the Parliament of this country, at that time, should have been correcting unjust pre-independence law. But we preferred the party. We preferred the party, rather than to have an industrious Parliament fix the law that needed to be fixed. Another matter of, and before I press on, so that the CCJ said in that case that the Parliament of this country should get on with the business of correcting pre-independence law as it relates to this amendment, so that without diminishing on the efforts of the Attorney General, the Attorney General has done what the CCJ is suggesting ought to have been done. And to that I add again that what is being done today ought to have been done a long time ago. And that we as legislators must spend our time looking constantly at law reform. There's so much law that needs reforming in Barbados. There's so much law that is antiquated. There's so much law that is irrelevant. There's so much law that needs to be updated with technological advances. Except that if that law, and I repeat, if that law had been pre-independence law, you cannot challenge it. If you felt that that law offended against the fundamental rights provisions. So that this law, we've been brought to this place by the Caribbean Court of Justice. And this Parliament must be even more industrious and on its own initiative must look at all those pre-independence laws which need updating. The case also highlights, Your Honor, the relationship between two arms of the state. The relationship between the judiciary and the Parliament. I think the public needs to know that there are three arms of the state. When I say the state, I'm not talking about the government. There's always a time to explain to the public what is the state and what is the business of the state and why the state must exist. The state is that human community which has legal responsibility for the security of this entity that we call Barbados. That's the state. It's a human community. It is a collection of human beings. The state is not the government. The state is an entire human community stretching beyond the government. And that state gives power, or rather, power is given to three entities within the state. Those three entities, the legislature, this Parliament, which includes, of course, the Senate, which has the responsibility and the sole responsibility for passing laws. Because we all exist under law. No one is above the law. That is why we talk about the rule of law. The rule of law implies that none of us, no living person in this country can function above the law. And so this Parliament always has the responsibility for passing laws. And that's a serious responsibility, because when that law is passed, all persons become subject to it, and all persons must obey it. The judiciary, Your Honor, they will say to you, and they will say to the country, that they do not pass law, they do not make law. Some people challenge that. But it is their responsibility to interpret the law. And of course, the other arm of the state is the cabinet. And it is the cabinet that has responsibility for managing the day-to-day affairs of the country. And they do that by setting policy. They do that by executive action. Now, I referred to that relationship between the three bodies of the state to indicate, Your Honor, that not one of those bodies is superior to the other. Some months ago, when this Parliament was differently constituted, I heard a member, since disappeared from here, saying that he would take action in relation to certain matters pertaining to the judiciary. Now, that statement was an unhappy statement. It was unconstitutional, for one. The legislature, neither the legislature nor the cabinet has any authority or supervisory authority over the judiciary. The legislature, that is to say the Parliament, the cabinet, and the judiciary are equal under the Constitution of Barbados. They are equal. They have power, the power within one, does not exceed the power within the other, except, of course, that they're separate. Being separate, one is not superior to the other. The only supreme entity in this country, the only thing that is superior to those three arms of the state is the Constitution of this country. Because all three of those arms of the state must function according to the dictates of the Constitution, and that is why we say, that is what we mean when we speak of constitutional supremacy. The Constitution is supreme. But we are brought to this place in this event today because the judiciary has ruled in this case that pre-independence law conflicts with the fundamental rights within the Constitution. The Constitution itself had said since 1966 that you could not challenge any law if it collided with the fundamental rights within the Constitution. The CCJ has departed from that. And that is what is so significant about this decision. The CCJ has departed from that. And the CCJ, it is the CCJ. One may even go as far as to say, perhaps the CCJ has taken a political initiative. And I want to say that many of us who describe ourselves as progressive lawyers may well agree with them. That 52 years into your independence, you cannot have your laws kept back by a provision in the Constitution that says you must keep all law. So it is the CCJ that has sent us here today on this, with this mandate that pre-independence law, if it is unjust, it has to be dismantled. What the CCJ has done, Your Honor, there's a sense in which the CCJ itself has promoted the dismantling of Section 26 of the Constitution. It is the CCJ that has promoted the dismantling of the Savings Law Clause in the Constitution. And as I said before, Belize long anticipated this situation, and they passed a law within their Constitution that their Savings Law Clause would last for only 5 years, and at the end of 5 years, it ceases to be of any legal effect. We've waited 50 years to do what the Belizeans had the courage to do when they became independent. Finally, Your Honor, the issue of punishment. As I said, there is nothing that touches public sensibility as much as punishment. I am willing to wager that we live in a country in which people are agnostic on things like the existence of God, things that it is said cannot be proved. I don't believe I will ever meet a person who is agnostic on the question of the death penalty. I can't say where the majority stands on it, but I know everybody in this country feels strongly about the death penalty. They feel strongly either for it or they feel strongly either against it. And again, I say, this is a discussion, this is a debate in which the public must make that strong emotional investment as to whether we should continue with the death penalty. And we hasten to make the point to Barbadians that this amendment today is not abolishing the death penalty. It is not abolishing it. What this amendment is doing today is that this amendment is giving the judge, as the Honourable Member for Christchurch, he said, it is giving the judge a discretion as to whether he or she will impose that penalty. of death. I submit, Your Honor, it is a very heavy responsibility. A very, very heavy responsibility. I would not read exhaustively where the judge is invited to exercise his discretion, but it is obviously in extreme circumstances where it is heinous, where it really offends humanity. If you kill a baby, for example, it also aims, this amendment also aims to protect the very existence of the state. Where you kill a police officer, for example. Where you kill a judge, for example. A judge has a responsibility for hearing a case of any nature. A lot of people leave the family court, and when they leave, you hear them. So many houses are burnt after the family court adjourns on Fridays. They're going to burn the house. They're going to burn the car. They might kill somebody. So that it is not only in the criminal court in which the judge becomes exposed to potential danger, but it is the court in every jurisdiction, and particularly in family jurisdiction. A lot of people leave there believing that they have not had their rights defended and they're going to kill somebody. And so, in the event that that threat is ever carried out, a future judge becomes entitled to consider that if that were the motive for the killing of a judge, I have no doubt that his lordship or her ladyship will indeed sentence the person to death for killing his brother or his sister. But I've asked the question earlier, and I will ask it again, so that the public may consider this. Is that heavy responsibility to be placed properly into the hands of a single human being, a sole human being? Or the persons who heard the trial, 12 persons sit in a room and hear an entire trial for 2-3 weeks. Then they sit and deliberate, sometimes up to 5 hours, so that they have a command of the facts. They have a better grasp of the facts than any other person. They don't derive their facts from gossip nor from social media. They derive their facts from what they heard in the courtroom in the form of testimony.
Member has 5 minutes more.
Thank you very much, sir. Is that body of persons, or should that body of persons participate in the imposition of the penalty of death? I remind you as to what I said earlier, Your Honor, that there are parts of the world, and I think in the United States, where the jury participates in the penalty. We are asking people in this part of the world to place that responsibility on the shoulders of a sole judge. And we looked at the various instances in which the judge may sentence a person to death. As I said, where, for example, he's killed a helpless child, where the person killed was a member of the police force. And let me happily say to the member for the city that this includes members of the defense forces, so that the amendment is aimed at protecting the very existence of the state. You cannot target your state officials. And if you kill your state officials, the inference is that you're trying to destroy the state. But then at the end, it gives the judge an even wider discretion. It says, in the opinion of the court, there are any other exceptional circumstances which must be taken into account and which justify the imposition of a sentence of death. Now, it is not for us to guess at this point as to whether this amendment will ever be employed in this country. The last time this country did it was on a sunny morning in June 1984. I remember a man indicating to the media that he went up there because he likes to hear the clap of the trap door. There are some people, death and punishment by death appeals to people in all kinds of weird ways. We like to be more dispassionate in matters of the penalty of death. But I will end by saying this, Your Honor, to you and to my colleagues and to the public of Barbados, just to remind that this is not a partisan issue, this is not an issue where there are political barriers, this is an issue of personal conviction, and that personal conviction may even find its basis in religious beliefs. It may do so. But to consider that even after this becomes law, that we must not leave it, Your Honor. That this Parliament must find itself in the not too distant future debating the question of a system of degrees of murder, as in other countries. I think that time has come. I think the time has come when the degrees ought to be extended beyond what we have presently. At this point in time, we only have murder and manslaughter. That is all we have. And to be honest, sometimes you get a sense that a jury believes that the verdict or the penalty for murder is so severe that what may otherwise be murder, they reduce to manslaughter. I'm not a prosecutor, but I will say this, that I suspect that there are juries who have found men guilty of the lesser offense of manslaughter simply because they don't want the man to hang. There are cases in which they may well believe that it fits within the category of murder, but they go for manslaughter as a compromise, which is consistent with my earlier view that juries in effect sentence, and that juries sentence by reducing murder to manslaughter if they don't want the accused man to hang. And so I think the time has come in this country, and I say this from a very personal position, that we ought to be introducing degrees of murder so that jurors have a clearer picture as to what they're dealing with. It could be first-degree murder, second-degree murder, third-degree murder, and beneath that, manslaughter and the other homicides by misadventure and so on. But the point I make is that we have the opportunity, and I urge the Attorney General to move beyond this legislation and to progress the issue of the death penalty under the Constitution of Barbados, to progress it further, where men can feel that they're going to get a fair trial in the courts, and where the relatives of the deceased will feel that their matter is so respected that the system is willing to treat it with due respect. And I think that is the point we have reached. In the 30 seconds I have left, is it that or is it more than that?
Conclude.
I want to respond to something the leader of the opposition raised about forensics. We've had forensics around here for a long time, a very long time. Forensics have made murder cases a lot easier. I think the first murder case that relied on forensic evidence was done sometime around 2006. That is 12 years ago. So that we do have a forensic laboratory. It certainly has made rape cases a lot easier to deal with because the man cannot say he did not do it if they prove that the semen is his. His defense then becomes reduced to that of consent. But a lot of men used to come to court and say, me, I did not me, I wasn't there. But forensic evidence can place him there, quite literally and physically places him there. So it reduces his defense and therefore promotes justice. So I want to assure the leader of the opposition that forensic evidence is alive and well in this country and that it has saved the courts a lot of time trying to deal with people who dispose themselves to telling lies for the purposes of freedom. I suspect this debate will continue another time. I will end by urging the Attorney General to do what the past Parliament has not done, and that is to become industrious, to get busy with the laws of Barbados, to look at pre-independence laws, which are unjust, and to update them so that the Constitution is genuinely supreme. Because I say to you, Your Honor, that Section 26 denies the supremacy of the Constitution in which it is contained. We do not yet have a Constitution that is supreme if it allows pre-independence law to govern our modern reality. With that, I am obliged to you.
Thank you. Member for St. John.
Mr. Speaker, I wish to participate in this debate for a couple of reasons. I am forced to drink from the chalice of forgiveness and leniency as it relates to this particular bill. And I must admit that I would have vacillated a lot on this issue, if not for the simple fact that I am the father of three. And the reality is that the Honourable Member for Christchurch East would have mentioned, and the Leader of the Opposition would have mentioned the mitigating circumstances as it relates to the punishment of the death penalty. And I want to take this opportunity to be pointed in relation of some of the areas, or one particular area that I believe would strongly factor into the mitigating circumstances. And if you look at the court cases, more often than not, you would see youngsters from a socio-economic background that speaks to struggle. And I want to be pointed here as it relates to parenting. And I'm not going to point the fingers at the females in Barbados, because I too could have gone in that direction as a product of a single mother. But I want to point the finger today, Mr. Speaker, at the fathers, or maybe those persons who donate sperm in this society and masquerade as fathers. Because I believe that if the men in this society took greater responsibility at what we know as parenting, what we know as fatherhood, then the situation that we see reflecting in the daily papers about those guys who are facing the law courts for the death penalty would not be there. Now, I am not saying that if you parent at a particular level that you will not still find youngsters who go rogue, as we know it. But the reality is that the block culture in Barbados will not in any way reduce itself soon. Because every day we have youngsters from in communities who are gravitating to the blocks because it is the only solace for these youngsters in life. There's no love at home, there's no father figure to actually guide them in a particular direction. And hence, the influence of peers will always redound, in some cases, to youngsters making decisions that will place them before the courts. So again, I see that as the mitigating factor to remove the mandatory death penalty from some cases that we know as murder. And I really want to send a message to the men in Barbados that if you enjoy a couple moments of ecstasy, I am saying that after that, the results, you must man up to what is happening after that. Because if we don't do that, in the constituency of St. John, in your constituency next door, Mr. Deputy Speaker, we're going to constantly see a flow of youngsters who will again and again and again end up before the court. And I spoke about sipping from the chalice of leniency. And we have examples of giants who would have walked this earth. Giants in the form of Martin Luther King, who forgive those who would have done major damage to our lineage in the United States. We have kings like, giants like Nelson Mandela, who in South Africa had to face some of the most trying times and came out forgiving those persons. So I am saying the mitigating circumstances that are there is the only thing that make me support, in a sense, this particular bill as it relates to removing the mandatory death sentence. Because I understand that those issues, those socioeconomic problems that we have across Barbados must be fixed if we are to reduce the court system that we will see youngsters engaging in murder. Last month at the Vatican, Pope Francis would have made changes to the Roman Catholic teachings as it relates to the death penalty. And he would have suggested that he is pushing that the Catholic Church worldwide move away and push for the total abolition of the death penalty as we know it. So I am saying, Mr. Speaker, this particular piece of legislation has been happening from May 24th, is one that is very progressive, is one that is well thought out by the Barbados Labour Party. The Attorney General is doing what is required in order to make the whole country safe. The legislation that is coming is proactive legislation. It is one that will, at the end of the day, redound to a better society. And hence, I have that particular interest in supporting this bill as it currently obtained. And the reality is that the Honourable Member for Christchurch East would have identified and clearly outlined a situation where a youngster was able to turn his life around. And I believe that we should not deprive persons who are seeking redemption to have that redemption and have that redemption coming from the state. So therefore, those guys who found themselves in situations of bad company or in a situation where whatever it is went wrong, and the remorse is actually there, and we can see the fact that there is remorse, must be provided with a second chance in life to show that, yes, I would have done wrong, but now I have recovered and I am prepared to give back to society. And we must find a way to reintegrate those particular guys into mainstream society. And I have been part of the process for the better part of 20 years in terms of reintegrating those youngsters into society. And I'm aware that there is a particular program now that is targeting the blocks across Barbados to do a similar thing, to reintegrate. And the fact that we're able, as legislators, to come here and to put forward legislation that will again allow some families to have that recourse of knowing, well, my particular son, my daughter will not suffer the consequences mandatory of going to the hangman. I think that that is a plus. And I'm speaking and not leaving out the victims, because I am fully aware, I'm cognizant of the fact of the pain that is visited upon the victims as a result of murder. And hence the reason why I said, first and foremost, as a father of two daughters, I have vacillated with the issue in terms of where should I treat to the fact. But that chalice of redemption, that chalice of leniency, with a level of maturity, I think all of us on this landscape are forced to drink from that chalice as it relates to how we treat to our fellow man. And the Barbados Labour Party is leading by example as it relates to that. Now, I am aware that those persons as well who embrace pro-life are seeing abortion as being more prominent than the death penalty. And that maybe I can understand as well. But the truth is that I think that this will resolve in the minds of some persons, well, look, this is a fair government, and those persons who go before the law courts will be given an opportunity, a real opportunity, to turn around and maybe contribute in a special way to society. And the reality is that in every society, there must be measures put in place to curtail certain levels of crime. We are looking at putting measures in place to curtail the ZR culture. And the sanctity of life is something that is, it is important. And those persons who take a life, I know there are lots of persons who believe in that adage of an eye for an eye. But the reality is that, again, we must look at every single case based on the circumstances surrounding that case and understand that we must protect those who, in some cases, find it difficult to think for themselves. So this particular piece of legislation, I believe, is timely. I believe that we're doing what is necessary to move this country forward as far as the legal aspect, as far as the social aspect is concerned. So I really, like I said today, want to embrace this, and I think that I would have contributed what I had to say as it pertains to this. But Mr. Speaker, before I take my seat again, I want again to place particular emphasis on the fact that the men in Barbados must man up to their responsibility of fatherhood. And it can't be a case that you're walking around in tie and driving big rides and all the rest of it, and the children that you produce are suffering. And I know from first-hand knowledge that this is happening in Barbados. And females are facing the court system in the most, embarrassing circumstances to collect money. And you have fathers out there who are not interacting with their male children. And it is forcing those youngsters to look for love on the blocks and in grouping that will only lead to a negative finale. Mr. Speaker, I'm obliged.
Thank you. Member for St. Michael South.
Thank you, Mr. Deputy Speaker, sir. I rise to support the Honourable Member for Christchurch East on this presentation this morning. And while there is a vacation early and leave will have to come at the day, rights are wrong with that penalty. Today, sir, is not that day. But I also know that we said and we promised as a government that when that day comes, we would have a much larger conversation than the 30 of us in this room. And indeed, whether or not we proceed to have a conversation on the death penalty and how we decide to move forward will depend on what the people of Barbados say they want to have through a referendum. But today, sir, I want to speak specifically to what was raised by the Honourable Member for Christchurch East, and truth be told, I found it to be very passionate and very powerful, and in some parts, very poignant. And if all that he said, and I know it is true, and considering that all that he said is true, and considering what I also happen to know, the bit I know about the law as it relates to this particular case, I believe that we, as a government, is simply doing that which we know have to do. But before I move on to speak specifically, though, to the amendments before the House, it is, as the Honourable Member for Christchurch, he spoke, I reminded myself he reminded me really of a poem by Oscar Wilde, The Ballad of Reading Jail. I don't know if you've read it, Mr. Deputy Speaker, sir. But it is a most powerful piece where Oscar Wilde finds, the reality is that Oscar Wilde was in jail at the time he came up with the piece for a crime that today many men would not consider to be a crime, but he was in jail for a crime in his time. And at the time he penned the piece, it was that a man had been brought to jail for having murdered his wife. But the poem doesn't speak to whether or not it was right or wrong to commit the murder. It just spoke to the reality of being on death row and hearing the gallows being swung every morning as they made sure the gallows worked, people making jokes at you, taunting you as you were there on death row. And he said, I know not whether laws be right or whether laws be wrong. All we know who lie in jail is that the wall is strong, and that each day is like a year whose days are long. And I could just imagine for a man who finds himself on death row, that the days are very, very long. And in the circumstances that the Honourable Member for Christchurch East spoke to, I could imagine that those long days would even be longer. And so I look forward to when we have that conversation on the death penalty in further detail. I really do. Not when we discuss the removal of the mandatory provision for the death penalty. And there will be a day when we have to talk in more detail about the death penalty, and I look forward to that conversation. I will tell you why. I have friends who were murdered, sir, Mr. Deputy Speaker, more than one. And I have friends who were also accused of murder. I have a very good friend who was on death row. And in fact, I saw him last week or so because he's now a free man. And sir, I will speak when we get to that point on that issue from a personal perspective. But today, sir, is not that day. I believe, sir, that what we are here to do, in essence, is to correct a wrong in the legislation. That is how I see this. And that, essentially, for me, the mandatory death penalty takes away the freedom that we in Barbados wish to associate ourselves with. In a way, anything that denies freedom denies human development and human expression. And in a way, that is where we are, sir, as a country. I heard the Honourable Member for Christchurch South say that he would hope the Honourable Attorney General would do his work and continue to bring legislation to the House. And I think it is necessary, because the reality is that for the last 10 years or so, there have been a number of cases of all kinds that should have been brought to this House for discussion, things that should have happened in Barbados that did not happen. And I will probably speak to that in more detail later, but that we have to do the people's business when we come to this House. So, sir, the mandatory death penalty is on the decline everywhere. It is not only a case where it is happening in Barbados, and it is on decline largely, I am told, because of judicial challenges. And that since 2000, at least 18 countries have discarded the mandatory death penalty. Some concluded that it was unconstitutional and arbitrary and inhumane. So, Mr. Speaker, sir, Mr. Deputy Speaker, sir, we are doing in Barbados what other countries have already done. In fact, in 1976, the US Supreme Court was one of the first courts to strike down the mandatory death penalty. So at the end of the day, we are not taking away the power of the death penalty, or for a judge to say the person is condemned to die. We are saying that it is not mandatory for the judge to condemn the person to die. And sir, so I want to make it very, very clear that this government is not taking the death penalty off the books, but that we're removing the mandatory death penalty. And it's also been the case, sir, with international tribunals. They have likewise condemned the mandatory death penalty. And sir, what the Caribbean Court of Justice did was in keeping with international applications, I believe, of the law. And it was what was considered to be one of the most significant judgments of the CCJ, when they unanimously declared the mandatory death penalty was unconstitutional in Barbados. They decided that the mandatory death penalty was unconstitutional in Barbados. the Caribbean Court of Justice, our highest court, sir. We are seeking, therefore, to execute that which has already basically been decided by the court. That is true. The honourable member for St. Peter is reflecting on my use of the word execute. But the court rules, sir, that not everyone convicted of murder deserves to be executed, and the court should be allowed to consider each case separately. They also went on to say, sir, that the Parliament was wrong to legislate for an automatic death penalty because under the Constitution of Barbados, the selection of punishment must be exclusively performed by the court, and that we had somehow reduced the court to a rubber stamping institution. So in essence, sir, we are doing what we have to do. But I do look forward to having a much larger conversation on the death penalty and engaging wider Barbados in that conversation. And so I began by saying that in my mind, this is about human development and human expression. And today we make no judgment whatsoever on the rights or wrongs of whether the death penalty should or should not be allowed to continue in this country. I listened very closely to the honourable member for St. John, and I know how he feels about community work, and I share his views entirely as it relates to the struggle faced by people of lower socioeconomic status and the almost let me rephrase. I share his views before I say something that is not necessarily fit for this honourable place. But I share his views, and I know it is disproportionate in the way that persons born into certain classes may find themselves one before the court and two guilty. And that has always bothered me about the death penalty. But there will be a conversation for that at another time. And we don't make that judgment today. But I believe that Barbados must be able to choose for Barbados. And that we must empower the persons that we ask to be responsible for administering the laws of this country to be able to make the choices that they have to make. And that we are seeking to correct a wrong is simply that we are now seeking to correct a wrong. But what strikes me most of all about this whole thing is that for the last 10 years, I mean, it has affected both governments, but certainly the movement has been such in the last 10 years that other people have gone ahead and done it, that we have taken so long as a country to right some of these wrongs. For the last 10 years, there is a level of inertia, or had been, in this country that is perhaps unparalleled in the governance of the affairs of this country. And it is not only here. You would see the Attorney General, again, the member for Christchurch South said it, but you would see that the Honourable Attorney General, Mr. Deputy Speaker, sir, has been very, very busy trying to bring legislations to bring Barbados into the 21st century. And that we had a government that at best, sir, is guilty of doing absolutely nothing for the people of this country for 10 years. And at worst, which is probably a more accurate reflection of who they are, have done tremendous damage to the country and to the people of Barbados over the last 10 years. And I will tell you why I say that, Mr. Deputy Speaker, sir. Every single indicator, every index that matters in relation to a country's development, it is not only here that they haven't done what they were supposed to do to right these wrongs. If you were to look at our position on the Human Development Index, Barbados has fallen. If you look at Barbados' position in relation to the International Maritime Organization, we just did an audit, we filled 21 areas. Barbados has fallen. If you look at Transparency International, the Doing Business Index, everything that matters, Barbados has fallen. Simply because people who were supposed to do what they are supposed to do did not do it. We bring legislation here to do what was supposed to have been done a long time ago, sir. And we are correcting wrongs in this amendment that the Honourable Member for Christchurch East brought, is what we have to do. We have now, I say to my people, we have to walk and talk at the same time. Engage the people at the same time we are doing the work. Because Barbadians should be aware of these issues that face the country. These issues, some of them not necessarily complex, but certainly they perplex people. And this is the removal of the mandatory death penalty, not in itself a complex issue, but a perplexing issue. And one that has caused all kinds of administrations grief. And we've come, sir, to correct that wrong. But at the end of the day, sir, we have to build the best Barbados. We have a responsibility, sir, to make Barbados the best that it can be. And that means in all things. I have said on more than one occasion that I have cared so deeply for the institutions in this country that have some responsibility for determining how people live, that I find it hard to accept that some of our institutions were so battered over the last 10 years. This particular chamber, this honourable house in which I have the privilege to be in, thanks to the people of St. Michael South, with a responsibility so important, bringing very little legislation to really positively impact on people's lives in the last 10 years. You heard how eloquently and passionately the Honourable Member for Christchurch East spoke this morning, speaking to issues that are pertinent to who we are fundamentally as a people, as we seek to address what really and truly is a wrong. You heard the member for St. John speak to our need for our community. In fact, you would hear all of us speak to it because we understand it, what it will take to move this Barbados forward and to bring it into the 21st century. And sir, maybe one day, maybe, hopefully soon, we will get to debate the death penalty. But today, sir, is not that day. And I make the point again that I don't want Barbados to walk away thinking that this Barbados Labour Party government came into this honourable place and somehow decided under the veil of night to slip the removal of the death penalty away from the arms and the authority of those who should have it, because we haven't done so. We have just removed the mandatory part of the legislation, sir. And sir, there will be a time when we will come to this honourable house, sir, and talk more deeply about governance and why it is that legislation coming out of this place should be frequent and why it should be meaningful, because these things matter to people. And, you know, I think if there is one thing that perhaps we probably need to do more as a government, and I know we've done a lot of it, certainly more than any other government, it's to continue to share with the ordinary man and the ordinary woman in this country what it is that we do when we do it and what bearing it has on their lives. And I heard the Honourable Member for Christchurch East as he spoke to the young man who almost fell to pieces when he, without intention, had taken the life of another person, to have it read to him that he will be taken to a place to hang until his body was deprived of life. That's a serious thing. In the instance where you never set out to do it, in the instance probably where the judge, if he had an option, would not have read it, would lend a young man to have to take his own life. These things have real impacts on real people. And that is why we come to this honourable place on this day to correct a wrong. And sir, before I take my seat, I listen very closely to all who make contributions in this honourable house. I listen and I try to assimilate, I try to learn. I try to learn from those who were here forever, like the Honourable Member for St. Michael North, who deserves to be here, for 6 terms, and who I think the House should recognize has been, very recently, is 24 years uninterrupted in this place, along with the Honourable Leader of the Opposition. But I sit, sir, and I listen and I try to learn, because that is why we are here. We learn so that we can carry forward for the next generation. It is the same thing that we bring legislation to this House. The Honourable Deputy Speaker, sir, has been here for 30 years? 28 years?
24.
24 years as well? Well, sir, we commend you too.
This is stop it.
And these things are significant achievements. And to have done so, sir, and to do justice to your country, sir, I commend you. But I will never take this position where I stand here and I allow the people of Barbados to forget what it is that the last government has done to us. We are discussing something that they should have done. I find myself in a ministry grappling with things that they should have done. You can't find the paperwork. You can't find no money either, I'm told. But you can't find nothing. No kind of benchmark, no light post, nothing to guide you as a young minister in the ministry in the last 10 years. Sargasm on the course is acting like it's the first time they've seen it. You gotta start from the beginning. The Honourable Member for Christchurch is dealing with sewage almost from the beginning. Difficult things that should be, for us, sir, in a position to build on what was left. Nothing. We cannot let them, the good people of this country, forget. As I close, I want to tell you a story. It seems to me that they have decided now that they must share the members of the former government, and every time they see Kerr Humphrey, that they must give me some kind of advice, Mr. Deputy Speaker, sir. So I've now been advised 3 times by members of the other side, or former members. And I am a decent person. I don't shut them down. I listen and discard, Mr. Deputy Speaker, sir, because if you could do the kind of harm that you've done to this country, what are you talking to me for? What you talking to me for? Wait. So we come, sir, to do justice to the people and for the people of this country in all that we do. And every piece of legislation that we've brought here, sir, is fundamentally important. This amendment, this series of amendments that are now before this House, sir, are so significant in my mind to give the people we've authorized to make those judgments the freedom to make the choices. And fundamentally, that is what human development is, the expansion of freedom. And sir, I wish to commend the Honourable Member for Christchurch East and to offer my fullest support to these amendments. I am obliged, sir.
Obliged. Member for the City of Bridgetown.
I beg to move the suspension of the debate on this bill for further consideration.
The question is that further consideration of this bill be deferred. All those members in favor say aye.
Aye.
Those against say no. Methinks the ayes have it.
Mr. Deputy Speaker, with that, we've come to the conclusion of government business for today's sitting, and I beg to move the adjournment of the House until the House reconvenes on Tuesday the 18th at 10 o'clock in the forenoon.
Second. The question is that this House be now adjourned until Tuesday the 18th of September at 10 o'clock in the morning. All those members in favor say aye. Those against say no. Methinks the ayes have it. This House is now adjourned until the 18th of September at 10 o'clock in the morning.